Good day everyone, especially to you sir. I am Regine Pisonor from BS Cream 4D and I'll discuss about the criminal procedure, Rule 110 prosecution of offense until Rule 126 search and seizure. Rule 110 prosecution of offenses. When we say complaint or information, the complaint or information shall be in the name of the people of the Philippines and against all person. When we talk about complaint, is a sworn written statement charging a person. Information is an accusation in written statement charging a person with an offense. So, institution of criminal action for offense were a preliminary investigation by filing the complaint proper office. The offended party cannot prosecute if they consented to the offense or pardon the offenders. So, proceed to Rule 111. Prosecution of civil actions. Criminal actions include civil liability unless the civil action is waived, reserved, or filed separately. What is the general rule? So, the general rule is when a criminal action to institute the civil action for the recovery of civil liability arising from the offense shall be deemed instituted with the criminal action, except when the offended party. What are the difference between crime and quasi-delict? So, crime are punished only if there is a law for their punishment, while quasi-delict include all acts where fault or negligence intervenes. When is the separated civil action is suspended? So, after criminal action has been commenced, the separate civil action until final judgment has been entered in criminal action. So, Rule 112, preliminary investigation. A preliminary investigation is conducted to determine probable cause. So, probable cause, such fact and circumstances which could lead reasonably discreet and prudent man to believe probably guilty. A preliminary investigation happens before an arrest. Preliminary investigation authorized to conduct preliminary investigation is the provincial city or prosecutor assistants, national and regional state prosecutor. Requires a preliminary investigation before filing a complaint for offenses punishable by at least 4 years, 2 months, and 1 day. Rule 113, arrest. Arrest is a taking of a person into custody in order that may be bound to answer for the commission of an offense. So, execution of warrant shall be caused the warrant to be executed within 10 days from the receipt. Within 10 days after the expiration, make a report to the judge. So, the time of making of arrest. So, made on any day at any time of the day or night. Duty of arresting officer. Execution the warrant of arrest and to deliver him to nearest police station or jail without unnecessary delay. Rule 114, bail. All person except charged with the offense punishable by reclusion perpetua, life imprisonment, or death penalty When evidence of guilt is strong, penalty. Evidence is guilt is strong, no bail. So, bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman, to file bail into the court where the case pending with any regional trial court. So, there's the purpose is to guarantee to appear in hearing upon during trial. Bail is the right and provision of dismissal. So, continue. Rule 115, right of the accused. The presumption of innocence, the accused is presumed innocent until proven guilty. Right to be informed, right to fair trial, right to confront witnesses, right to present a defense, right to remain silent, equality. So, Rule 116, arraignment and plea. The accused is formally informed all the charges in open court and enters plea, guilty, not guilty, or other lawful pleas. Arraignment ensures that the accused understands the nature of the accusations. Arraignment is mandatory and it takes about the issues or joined or combined formally informed of the charge against him in open court. Fairness, fairness to the accused, efficiency if the legal system protect the rights of the accused. So, Rule 117, motion to quash. The accused may file a motion to quash the complaint or information on grounds like lack of jurisdiction or insufficiency of the charge. So, the time to file motion to quash must be filed at any time before entering his plea before the arraignment. Criminal complaints subpoenas, court decision, or a lower court. So, the purpose of motion to quash is to avail the validity of a criminal information, which is why we said that a motion to quash is a special pleading, because it sets into a question that the validity of criminal information. Rule 118, pre-trial. So, pre-trial is mandatory in criminal cases recognizable by the Sandigbayan Regional Trial Court. A pre-trial conference is held to clarify issues, identify evidence, and explore possible plea bargaining to expedite trial. Clarifies issues, clarify and limit main issues between the parties. Expedited trial prevents surprise, ensures all issues are raised. So, Rule 119, trial, outlines the proper conduct of a criminal trial, including the prosecution of offense, of evidence, examination of witnesses, and sequence of proceedings. Structure of the trial. Speedy trial, demurrer to evidence, witness examination, reopening of proceedings. Rebuttal evidence is given by the accused. So, rebuttal evidence is given the prosecutor. So, Rule 121, new trial or reconsideration, allows the accused to seek a new trial or reconsideration of a judgment based on the errors of law or newly discovered evidence, ensuring that justice can be corrected when the original trial has flowed or when information comes to light that could change the outcome of a case. Rule 121 allows the court to resist the case and potentially grant new trial or reconsideration grounds of new trial. That errors of law, irregularities prejudicial to the substantial right of the accused has been committed during the trial. This means that mistake or problems during the trial affected unfairness of the case of the person being accused. Second, that new and material evidence has been discovered which the accused could not be reasonable diligence have discovered and produced at the trial, and which it introduced and admitted would probably change the judgment. The importance of evidence has been found that the accused couldn't have found before if this evidence has been shown during the trial. So the last rule is 126, search and seizure. So the issuance and execution of search warrants and ensures compliance with constitutional protections against unreasonable searches and seizures. These rules are designed to ensure the fair. They also emphasize the importance. Requisites for issuing search warrant. A search warrant can only be given if there is a good reason to believe that a crime has been committed. Validity of search warrant. A search warrant shall be valid for 10 days. Time of making search warrant. Search to happen at any time, day or night. Motion to quash. A search warrant or to suppress evidence or to file a motion to quash. A search warrant means asking the court to cancel the search warrant because it was issued incorrectly. Motion to quash to suppress evidence means asking the court to not use certain evidence found during a search if it was obtained in a wrong or legal way.